Hi, I'm Keith Moten, the principal of Moten Associates. I'm coming to you today with a video, the 4 most common misunderstandings about estate planning. First, a little bit about myself. My name is Keith Moten. I'm an attorney. I'm licensed in California and Georgia. I'm the principal of Moten Associates. We have offices in Los Angeles, California, and Atlanta, Georgia. The 2 areas that we specialize in are business, which includes corporate work, litigation, as well as estate planning, which is estate litigation and estate planning. So we've been a part of setting up estate plans, setting up businesses, and also the litigation involving the disputes involving those businesses and estates. So without any further ado, let's get straight to it. Number 4. The number 4 most common misconception about estate planning is that wills don't require probates, which is totally false. If you have a will, you will have to file a petition for probate in the Superior Court of the county in which the person passed away and undergo the probate process, which normally takes up to in excess of a year and usually is considerably more expensive. So to dispel that rumor and that misconception, if you have a will, your estate still does have to go through probate. Number 3, the 3rd most common misconception about estate planning is that if you have a trust, then you can avoid litigation. This is not true. A poorly written trust opens you up to more litigation because if there's some sort of ambiguity in the clauses of the trust, then someone, usually the person that's going to be the most adversely affected, is going to sue over it because they may read it one way, whereas everyone else may read it another way. Trust me, I've been a part of many cases where we're fighting over a clause that's written badly or ambiguously. The second part of that is no contest clauses. There's a common misconception that no contest clauses prevent people from challenging your trust, but that law has been changed. In California, you can only invoke a no contest clause if the contest was unreasonable, if there were no probable cause, which is something that actually gets figured out after the lawsuit has been filed. The bottom line is that you really can't do anything to stop someone from suing involving a trust, but we'll get to that a little bit more later. Number 2, the number 2 most common misconception about estate planning is that trusts provide asset protection. This is completely false. If you have a trust, you can and will be personally sued, or at least personally liable, because all we as attorneys do is just name you as a defendant individually. We name the trust as a defendant, and the trust does not serve as a bar to personal liability, because a trust is just a relationship. A trust is a fiduciary relationship between a trustee and the beneficiaries, but it does not shield you from personal liability. In order to have a liability or a shield from personal liability, you have to get an LLC, because a LLC or a corporation provides that asset protection. A trust does not. We'll cover that in some subsequent videos on how to get that succession planning that you get with trust, in addition to the asset protection that you get with the corporations and LLCs. But for today, I want to make clear the point: a trust does not provide asset protection. So with that, we get to the last point and the most common misconception about estate planning. The number 1 most common misconception about estate planning is that you can do it yourself. All right? So there's some limited instances where if you don't own any property or own too much, then yeah, you can do a simple will and indicate where you want your personal property to go, your car, your baseball glove, memorabilia, clothes, jewelry, stuff like that. And I think that's fine. And it can come in handy because you want to leave behind some record of what you want, right? But if you own a house if you own businesses, if you own any sort of asset, and significant assets, and by significant I mean anything that's more than a little bit, right? So if you own something that's worth something, I highly advise not going to LegalZoom, not going to a paralegal, because as a litigator, right, as litigators, we love to see trust done on LegalZoom or trust done by paralegals. Why? Because there's always going to be something that's not right. Right? And when there's something not right, then attorneys tend to jump all over because we get hired by people that are seeking to undo what you wanted to do in that trust. Right? So ultimately, it's not worth it. The money that you think you may be saving by going to LegalZoom or going to a paralegal, that money gets eaten up on the backside because it will 100% be challenged by the attorney of whoever it is that you don't want to receive that property or that asset. So don't try to do it yourself. Go see an attorney, even if it's not us. You can always come see us. If you like this video, you can like and subscribe. We have a YouTube channel here, Moten Law Firm. There's also an Instagram channel, Moten Law Firm. Please like and subscribe. Look out for more videos coming your way. Take care.